Welcome to this episode of Risk on Air. Costs can be a problematic and complicated aspect of legal practice and are often a catalyst for complaint. The issue of costs is under increased scrutiny, and with a competitive and savvy market, solicitors are under pressure to offer quick, accurate and cost-effective solutions. This can leave you exposed to risk and complaints. In this podcast, Jen McMillan, legal practice consultant at LawCover, and Jacqueline Highfield, Head of Chambers at Clarence Professional Group and Cost Law Specialist, will discuss the risk associated with cost estimates and fixed costs and how practical measures can be taken to manage this risk, maintain a happy client base and get paid on time.
Thanks so much for joining us today, Jacqueline.
It's a pleasure. Thank you for having me.
Jacqueline, we're going to talk about costs today, and I've noticed that while solicitors are generally happy to talk about most things, when it comes to costs, there's often a level of lack of comfort in having that discussion with their clients. And the thing that often occurs to me is that if other business people had this problem, it would be astonishing if a plumber came to your house and didn't want to tell you how much it was going to cost and then sent you a bill down the track, or was embarrassed to tell you how much it was going to cost. It would really shock us. We wouldn't know how to react. We wouldn't know whether to pay. But routinely, lawyers seem to stuff this up. Why do you think it is that lawyers are often uncomfortable having this conversation about costs?
I think there's a couple of reasons. I think we're a particular type of personality often, and often we're very good at what we do, but we're not comfortable about, as you say, saying what it will cost. The practitioners that I deal with in my daily working life will often say to me, if I tell people what it's going to cost, they'll go elsewhere. So there is that worry that, there's another lawyer down the street or across the road or possibly across the hall who, might steal their client. I think lawyers are often concerned about the client's reaction. So if I tell them what it's going to cost, they'll be horrified. We're not very good sometimes at articulating the value of what we do. So you go to my father-in-law, who's a periodontist, he fixes your gums, you're grateful and you're happy to pay. And in fact, you swipe your credit card on the way out. You go to the accountant, he sorts out your problem with the ATO or whatever it is. Often because when people come to lawyers, even if we get them the absolute best result, the absolute perfect result that they want, they're only going to be being put back in the position that they think they should have been in. There's a hesitancy on the part of the lawyer to say, well, this is what it costs, and also this is what I am worth. And I know our hourly rates sound high to people who aren't lawyers or other professionals, and many of us are very cognizant of the fact that what we charge per hour someone might make per week. But our hourly rate covers not just our time, but all of the business costs that go along with,
of course it does,
running a practice. So I think there's that, and I think there's lack of confidence or even knowledge about negotiating and about saying, well, I can do work for, I can do this amount of work for this amount of money, but if you need this and this done, it's going to be extra. I mean, I think your point about the plumber is very good. I took my car in to be serviced once, expecting it would be a straight service. And I got there and went to pick it up and I was told it was $4,000 and I nearly died.
Ouch.
Yeah, because, it can be a question of cash flow for the client. I didn't have $4,000. And when I said, well, it was meant to be like the $600 service, what have you done? They said, oh, well, we realised the brakes might need doing within the next 6 months and your air conditioning needed an overhaul and this, that and the other. But they'd done it without asking and they'd done it without notice. And I was horrified, absolutely horrified.
And fair enough too.
Yeah, I mean, the way I look at costs is if my dad was getting this bill or, he was in business for many years as a greengrocer, but he's not, a professional person. But if he was getting this bill or I was sitting and having a conversation with him about what it was going to cost, what would I tell him, and what would I know? I mean, we're in a two-lawyer household. And we jokingly say, we can't afford to hire either of us for any length of time because, lawyers are, cost a lot of money. Yeah. And when I say expensive, I don't mean as in unreasonably expensive, but I mean, the hourly rate of most lawyers practicing in New South Wales would be, not less than $300 an hour. And certainly many lawyers are charging $500 or above. Certainly justifiable based on practice costs, but clients need to be aware of that when they... Right.
Which means that you can't shy away from having that conversation. But do you have some tips for how to start that hard conversation?
Yeah. Look, I don't think it needs to be an uncomfortable one. And I think the more upfront you are about it and the earlier you have the conversation, the more relaxed you'll be about it. When I first sort of started working in this area, I was quite hesitant about saying to my lawyer clients, because most of my clients were lawyers, oh, well, we charge X percent or we charge this per hour. But I learned that you're not doing anybody any favours by not having that conversation. Often clients will hear two numbers. The smallest number you say it might cost and the biggest number you say they might get back. And it's really important that you don't minimise the costs and the risks of costs that are involved when you have those conversations. So I think if you can be comfortable and be frank about, the costs involved, not just your own costs, but disbursements, what might incur, filing fees can be very expensive, subpoenas, barristers' fees, if you need experts. People need to have a clear picture because they'll often tell you it's not about the money, it's about the principle. It'll be about the principle until your bill arrives.
And then it's about the money.
Then it's all about the money. But, people can't make a decision as to how they proceed or the risk that's involved for them if they don't know. So I think being upfront, being consistent in how you detail your costs and as concise as possible. I mean, we're all under obligations as legal practitioners under the Uniform Laws and previously under the Legal Profession Act 2004 and 87. We actually have a positive obligation to provide this information to our client. I mean, costs is part of our contract. If you think of it as a simple contract between you and your client, they can't agree to a contract if they don't know what the terms of the contract are. I mean, you're required by legislation to do it in writing, but I think having that conversation and having that open discourse is very important. Practitioners will often come to me when they have a solicitor-client dispute, so where the client doesn't want to pay their bill. And 19 times out of 20, if I say to them, was there a point where you felt the relationship was going off track? They will sit there and you can see a light bulb almost flicking on behind their eyes. And they say, oh, well, their client started to get a bit funny. They were a bit slow paying my last 2 bills. They weren't returning my calls or whatever. And you can almost pinpoint where the relationship has gone off track. And often it's because an estimate's been exceeded or because extra costs are being incurred. So I think there are ways around it as well in terms of looking at how you structure your billing and what updates you provide to your client. Some clients will want to be billed more regularly. Some might like fortnightly or monthly. Some matters you may not be able to bill until the end. I know a lot of personal injury solicitors and family law solicitors struggle with this because they can't charge until the end of a matter.
So you'd recommend that you not just have a conversation about what the cost is likely to be, but also about frequency of billing, get an agreement with your client or set up an expectation with your client about how often they're going to be receiving bills.
Absolutely. I mean, if you can do that from the start, then you've got a more open relationship, even if it is that your client's not paying you to the end, and so you may not want to raise a bill because you don't want to raise a tax liability and a GST liability. There's nothing to stop you giving them updates as you go along, saying where you're up to with those fees. But if they are paying as you go, small amounts billed regularly are much more palatable than one big lot at the end in terms of cash flow, in terms of understanding where you're up to. One of the firms I've worked with in the ACT have a great system that whenever they send a letter out to the client, they have a few bullet points, and the bullet points include original fee estimate, costs incurred to date, further estimated work.
Right.
And
so it's there all the time.
It's there all the time. Nobody's hiding, and clients don't like surprises. And when they feel that a lawyer has held something back from them on the cost front, that is when the relationship will start. It doesn't matter how good a job you're doing. If the client doesn't feel they can trust you in relation to billing and you're not completely transparent, then you're setting yourself up for failure in that relationship. So I think that's important.
Yeah. So, I mean, it's about trust, as you say. It's also about the client making an informed decision about whether they want to proceed with the legal work and whether they want to proceed with you doing the legal work. It seems to me that that's a time when there might be some risks that come up for a lawyer. Are there tips that you have for how you minimise risks when you're having conversations about costs?
It's always important after you have a conversation to follow it up in writing. Cost disclosure always needs to be in writing. I would always make file notes when you're having those discussions. I think it's very important to be clear about what your instructions are, the scope of those instructions, and not just what you're being asked to do, but what you're not being asked to do is very, very important. And I would go so far as to say that should be in your disclosure document. So in your disclosure document, and the Law Society has a fantastic template for members of the New South Wales Law Society on their website. And if you're going to use that, I would say don't play around with it too much. Don't chop bits out of it because you don't think you need it, because it's in there for a reason. And, you know, if you use a Law Society one, you can say, look, the Law Society has prepared this as a base document. I've filled in my details. I'm required by the legislation that I practice under to provide you with this document. And clients will understand that, you know, you're meeting your obligations. But I think in that document, it's very important to say what you are not providing an estimate for. So it may be that you're providing an estimate for the proceedings, which may be, say, a commercial matter relating to a debt, but you are not covering in your estimate the work associated with recovering any judgment. So put that there so that the client doesn't have that expectation that the $30,000, for example, estimate includes all of the work at the back end. You know, that $30,000 might only include getting you to the first day of the hearing or whatever it is, but you need to be very clear about that. I mean, ultimately, clients are going to make the choice to work with you based on how they feel about you, your level of expertise, your trustworthiness, the quality of the relationship they feel they can have with you. And if they perceive value, then they'll stay put. If they feel like, you know, you're trying to sneak around behind them, you know, you mentioned your hourly rate, but now they get a bill and you've charged them $1.50 per page for photocopying and they never even thought about it. They're the things that can ruin an otherwise really good working relationship.
And I guess it's not just the costs conversation that you have right at the beginning. You need to be referring back to where things are with costs, as you said, with the Canberra firm that keeps it front and forward all the time. But in terms of managing risk around the way things change as a matter goes along, do you have any ideas about how best to do that?
Look, I think one area you can manage risk really well, and it's not an area that's easy to get right, but it's important to focus on it, is how you do your estimates. If you can break your estimates down into manageable chunks that people understand, you're minimising your risk from the outset because you're actually turning your mind to what it costs. Often when I do talks, I pick things up from other practitioners, and the best way of doing an estimate I've ever come across was an older solicitor from regional New South Wales who said to me, I sit down and think, if I was doing a security for costs affidavit, love, what would I put in it? And I thought, what a great way to break. And he said, I do that right from the start. And I said to him, do you have any tips on how you manage the client relationship? And he said, I feel that if I'm getting that sense of dissatisfaction, like I just mentioned a moment ago, I get my secretary to call them and have them come in for a coffee. Now, if you're in a city practice, that might not always work, but you can pick up the phone. And I think there is a great tendency to not want to pick up the phone, to just send an email, and tone can be really hard to get right in email. Pick up the phone and say, how do you feel we're going? Is there anything you're concerned about? Always document it, always follow it up, because, file notes are your friend. You want to create that paper trail in terms of your own risk management. But it is really important to stay on top of where you're at with an estimate and to keep clients updated about it. My rule of thumb is to, however you record your time, whether it's on paper or you have an electronic system, and I see everything from the minimal to the over the top, somewhere in there have a system that if you get to about 70% of the estimate, some sort of alarm bell should be going off so that you know that you've got to sit down, look at the file and work out whether what you've got left in the kitty is going to be sufficient to get you to the end of the matter. And if it isn't, you need to be telling clients why, and you need to be doing it then and there. If things have changed that have affected your estimate, like someone becoming a senior associate within your practice and their rate going up, you need to be telling the client about that. It's all about transparency, and it means that you're proactively managing the relationship rather than reactively managing it. And I think being proactive can save you so many problems in the long run.
Yeah. So with estimates, where do you think that practitioners fall into traps? What are the problems there and what can you do to mitigate them?
Not giving an estimate is probably the first and biggest problem, because you are required under the legislation, under Uniform Laws and the Legal Profession Act for matters pre-1 July 2015. We've always, estimates are essential. You can't meet your disclosure obligations until you've provided an estimate, but it's not a case of tick a box, I've done the estimate, now I can forget about it. One of the big problems is updating of estimates and going along. As I said, I have that 70% rule. Not putting enough in the estimate to start with, not thinking about all of the variables, and that can be difficult to sometimes think about. It is an estimate, not a quote, so you need to be aware of that, and the client needs to understand that, and you need to convey that to the client.
So just explain to me the difference between an estimate and a quote.
Okay, so a quote, say you go in to get your car serviced and the mechanic says, I will service your car and it will cost $450 plus if I use oil, that'll be extra. That's a quote. If you go in and the mechanic says, or the lawyer says, I estimate that it will cost $450 and that's my best estimate, but I might need to spend a bit longer or I might need to spend less. There is an overriding obligation on lawyers under the legislation to not charge more than is fair and reasonable. So just because you do an estimate doesn't mean you can charge that. It's like fixed fees. Just because you say you're going to charge something doesn't mean you can unless you've done the work. So there can be a tendency with estimates for lawyers to think, oh, well, it's all right, I'm within the estimate, I can just do what I need to do. But the biggest tendency I see and the biggest problem is underestimating, not being prepared to actually bite the bullet and say what it's going to cost. And often that comes down to how you approach the estimate. As I said, that idea of thinking of it as a security for costs affidavit is a really good one because it really does turn your mind to how it's done. I find practitioners who work in the areas of probate and also family law, because part of their practice and part of the court's requirements in their matters is to provide cost estimates and statements, tend to be quite good at doing estimates. Other litigators can struggle a bit, and it's hard because when you at the outset of a litigation matter, you don't know whether the other party's going to play ball. You don't know how many interlocutory hearings there's going to be.
The variables are actually enormous in litigation.
They
aren't
are,
they?
and that's why it's really important to stay on top of it. And as I mentioned with the bullet points, turn your mind to it regularly and think about where are we up to. If you're at 70%, but you're signing the deed of settlement next week, you're okay. But if you're at 70% and you haven't got a hearing date, then you're really going to struggle. So I think that is part of the problem. In terms of, getting your estimates right, or at least having a decent crack at them, not only do you meet your obligations under the uniform laws, but you are able to, think about disbursements, turn your mind to it from the outset, think about your game plan for the matter as a whole. It reduces client uncertainty, and I find that if estimates are good, you manage the client relationship right from the outset. It also means that you're more likely to get paid on time. And our studies show that when lawyers suffer cash flow problems because they haven't done a great estimate, the client's then slow to pay, the client has a cash flow issue, that's when lawyers are more inclined to take on work that they're not good at doing. That's when they make mistakes. I mean, law covers.
Yeah, it's certainly borne out in our statistics. There's a real correlation between people who've got too much locked up in unrecovered time and people who are cutting corners or accepting work in areas where perhaps they shouldn't. Yeah.
It can be a problem. And if you're estimating something's going to cost $10,000 and you've spent $30,000, and I hear this from practitioners regularly, well, do I just write off the rest of the time? And if you're writing off even $5,000 and you're charging $500 an hour, that's 10 hours that you're not recovering, which is 20 hours you've got to do to get back to where you were. I mean, as lawyers, we sell our time.
That's right.
Along with
and
our
if you're going to be
expertise.
profitable, you've
got to recover
be
your time.
focused on it. Yeah.
So I think estimates really do come into that whole way of how you manage your practice. It's very important.
Yeah. So are there some things that you can suggest in terms of how you minimise those risks when you're providing an estimate to a client?
Look, I think it's important to be methodical and have a system as to how you go about doing your estimate, as I said. It's important to remember that the days of doing an estimate that were, I think your matter will cost between $50,000 and $150,000 are over. With the introduction of the uniform laws and the position taken by the Legal Services Commissioner in Victoria, it's become clear that that's just not acceptable.
Is it still okay to include a range though?
Look, I can't say any range, but it's very hard to not have any range at all. I think what is important is the size of your range. It needs to be very, very tight. And I think you need to break your estimate down into manageable chunks so that where you are having a range, you're not saying from 5 to 15,000, it might be 5 to 6,500. I mean, there's nothing in the legislation that says you can't have a range as such, but you've got to be very, very careful about it. The other thing you've got to avoid, it was very popular, 10, 15 years ago, I still see solicitors doing it now, is the providing a table that says, we estimate if you recover between 100 and 150,000, our fee will be 10,000. If you recover 150 to 250, it'll be 15. Now, while in your own mind you're not making the fee contingent upon the result, that's how that can be read at cost assessment. And there's an absolute prohibition on contingency fees for lawyers. Our fee can never be tied to what the result is. So that's a real risk as well. I mean, the risk with estimate ranges is that they're just too broad.
Yeah.
And you've got to remember that we're governed by consumer protection legislation effectively. So, is there sufficient transparency? That's the issue.
Yeah. I suppose in some ways, if you're doing the same kind of work frequently, it's easier to give a more accurate estimate. Would you recommend that even when you're doing, for example, a fixed cost estimate, that you still record your time and make sure that you're keeping a track of it?
Absolutely, and that's for a couple of reasons. One, under the uniform laws, the client can still ask for an itemised bill. So even if you provide a fixed fee or a capped fee, or even for a client that you do regular work, there's nothing to stop that client within 30 days of being given the lump sum bill of asking for an itemisation of your work. So you need to be able to provide that. If you're not recording your time, then you should be at least writing down file notes with start and finish times for the work that you do. The other reason that's quite important from a practice management and a risk management perspective is you need to know whether you're actually making money out of those files. And so if you're not recording your time, how do you know that the $3,000 or the $5,000 that you're charging is actually enough, or is it too much? I mean, I had a matter where I acted for a client whose former solicitors had charged a fixed fee. The fixed fee was in the order of $70,000. When they were asked to itemise the bill, the best they could come up with was about $27,000. But they thought because they'd done a fixed fee, they could charge it. Yeah. Fortunately for my client, the cost assessor disagreed. And I don't act for many private clients, but I thought in this instance it was appropriate. And on their own reckoning, they couldn't get past $27,000 in the itemisation. So it is important, and I think perhaps they hadn't kept time records. So I think that is really important. What's also important is getting sufficient information from your client when you first meet with them to actually be able to do the estimate and to break it down into those portions. And circumstances can alter over the course of a matter, but the more things you know up front, the better. It's also important to understand the client's objectives and expectations, because that can impact on how they utilise your services. And look at past matter histories. Look at work that you've done in the past can be a useful guide to, if you are going down that fixed fee route, or even just with estimates generally. Look at, often how do these matters play out? Get a feel for it. Talk to your colleagues. Bounce around. Ideas. I mean, we all know other lawyers. To say, look, I'm thinking of doing a fixed fee estimate in this matter. This is the background. Does that sound right to you? And sit down and think about what your hourly rate is and what number you're at the end. And if your hourly rate's $500 an hour and you're going to say you'll do the matter for $5,000, is it going to take 10 hours, or is it because 10 hours disappears pretty quickly?
Fast, yeah.
Particularly in anything involving litigation.
Yeah. And also, I guess you might want to think about whether that kind of work is the sort of work you want to be doing, if it's much less profitable than something that you could otherwise be doing.
That's right. You also need to take into account the risk factors involved in a matter. Do you have multiple clients that you're reporting to? Are there any third-party payers involved? So, where your client isn't the one paying your bill, but someone else. Is there a self-represented litigant on the other side? Because that can make life extremely difficult. Who are you briefing as counsel? You know, are your clients saying, well, I want everything done at a cut price, so you're using a counsellor who may not be as experienced as you would normally choose to brief? That can increase, you know, the risk that's involved. And, you know, as I said, bounce the estimate off someone else. One of the things we do in the law cover risk management briefings around costs and in the roadshows is we do cost estimate workshops. So I get groups who don't know each other and we give them a scenario, whether it's a litigated or a non-litigated one, and say, sit down and do an estimate for me. This is what you're charging per hour. These are the base background facts. Now, I don't care what the number is at the end. What I'm interested in is seeing the process. And I'm always really intrigued by how different groups approach things, and we always pick up points from each other. It's a really worthwhile exercise. I mean, if you're in a firm with, you know, other solicitors, or you're a sole practitioner but you know some other solicitors, maybe think about doing that as a learning exercise.
It's a great idea. Really great idea.
Because it really does focus you on the different approaches.
And opens your mind to the idea that there's not just one way to do this.
That's right. And, you know, and there's not just one way to do this necessarily within your own practice either. You know, different courses for different horses, different matters may require you to adopt a different approach, even if it's within the same specialty that you practice in.
Yeah. I want to circle back to talking about costing models. So you've mentioned fixed fees, but I think it would be useful to, and I can absolutely understand from a client's perspective what the appeal is with a fixed fee. But do you perceive that there are advantages and traps as well with using fixed fees?
I think fixed fees can be very useful if you do a lot of transactional work or you have a client who sends you, you know, regular matters. So you've got a large commercial client who sends you regular matters. I mean, fixed fee is not new. You know, 20 years ago when I was doing personal injury, insurers were insisting on a form of fixed fee, which was event.
And that was for litigation work.
For litigation work, event-based costing. You know, if you're a defendant lawyer, in insurance, you're very familiar with event-based costing. But what was interesting was how often we could get outside of the event and call it a catastrophic, because otherwise you didn't make any money. And I think that is one of the risks. I mean, I absolutely can understand why clients enjoy the certainty of it, but there is a risk that, one, you're not charging enough, and more often than not, I see with fixed fee costing, it's the lawyer who comes off second best because they haven't sat down and done an estimate before they've picked a number. They haven't benchmarked some files. And I think if you're interested in doing fixed fee, benchmarking is really important, and not just as a one-off, but, you know, every 6 months or 12 months.
So can you just unpack what you mean when you say benchmarking?
So benchmarking would mean sitting with some of your files, like a small, a medium, a large, and one that was odd, working out how long you actually spent on the matter. And if you did a fixed fee on it, what did you charge for it? And where does the time spent sit against what you charged? So if you are going to charge a fixed fee, say that you do regular commercial transactional work, actually sit down and work out, if you were charging on an hourly rate, what number you would be getting to. Of course, in the back of your mind, you always have to remember that the fee charged, whether it's a fixed fee matter or not, must be fair and reasonable for the work that's done. And the uniform laws impose a positive obligation on lawyers that the fee must be fair and reasonable. So when I talk about benchmarking, it is literally finding the benchmark for where matters sit, but doing it in a very methodical, organised manner, not just thinking, oh, that one was about 15,000. I mean, we used to talk in the old days about weighing the file. And I think sometimes with fixed fee, that's what's happening without a great deal of thought going into what's behind it.
I can hear practitioners saying, who's got the time to sit down and go through that exercise? What would your response be to that?
Well, time is what we sell.
Yeah.
You know, and if you're going to go with fixed fee and you set your fee as $5,000, but in fact, if you actually sat down and look at it, even if you're doing $5,500, for every 10 matters, you're losing $5,000. You know, if you're charging $5,000 and really you're doing $7,000 or $8,000 worth of work, that's a big haircut that you're taking on every matter. I mean, if you do want to go with fixed fee, you in some ways are streamlining the time you spend down the track, but it's like anything, you've got to put your effort in. And it's a twofold exercise too. You need to make sure you are meeting your legal obligations, and disclosure obligations are strict, but you also need, from a practice management and a business perspective, need to make sure, you know, that you are actually making money out of the exercise. I mean, you want to choose your pro bono matters, not have them thrust upon you. And, if you were selling something in a shop, you wouldn't just buy the stock wholesale and whack it up on the shelf and put a price on it without taking into account your rent and your staff costs. It is business at the end of the day.
Yeah. What happens if you've given a fixed fee estimate and then something happens in the middle of the matter and you decide you no longer want to act for the client, or you can't any longer act for the client because you have a conflict or something like that? How do you deal with that situation where you had agreed that you would do this work for this money, but you need to pull out?
Well, it's important that in your fee disclosure you have already provided for this situation and contingency. So in a fixed fee agreement, I would always recommend that you include an hourly rate, because you need a fallback position if you have to go back and cost out the work that you've done. And you need to provide in your disclosure document that in the event that something like you've just described happens, that the client takes their instructions elsewhere, or the client, for various reasons, and usually in a fee disclosure it will set out different situations, if you've lost confidence, if you're not responding, that sort of thing, that in the event that that happens, the hourly rate will be applied to the work, up to the amount of the fixed fee. Now, some fee disclosures I see say, well, we can just charge you an hourly rate and then can go beyond the fixed fee. I think that's very problematic. Right. I think I wouldn't ever try and recover more than what the maximum of the fixed fee was in those circumstances. But it's very important to have in the disclosure that if something happens before the resolution of the matter, the hourly rate will be applied. And that should be front and centre, and I wouldn't shy away from that, because how else are you going to calculate it? That's the reality. You can't say, well, it was half done, so I'm going to, charge 50%. Something I often get from practitioners around fixed fee is, oh, well, it swings and roundabouts. I might charge a bit more on this one, but I might lose a bit on the next one. Well, that's not how the uniform law works. The cost must be fair and reasonable to each client, and client A can't be picking up the loss you made on client B. So you always should have that.
You wouldn't be very happy to be client A.
No, that's right. Sure, client B, you're pretty happy, but that's very important.
Yeah. So when do you think that fixed costs are appropriate, and when do you think they're not appropriate?
Appropriate for, as I said before, transactional work, where there's a high degree of certainty around the amount of work that will be done. Not appropriate, if there is a high degree of risk or a high degree of uncertainty. Not appropriate if you're new to doing that area of work, if you don't really know how to scope it out. It may not be appropriate within your firm structure as well. It may just be that it doesn't work for you as a firm. Family law matters can be very difficult to do a fixed fee in, because the variables are so high, and sometimes the parties' behaviour can disintegrate very rapidly.
Yeah.
I think litigation matters are particularly hard to do a fixed fee in. But if you were leaning towards that fixed fee model, I think it would almost need to go back to that event-based costing,
right.
Staged fixed fees.
Yeah. So you'd talk about staging as being one of your risk minimisation strategies.
Absolutely. Because with staging, you're kind of keeping it more defined, what's involved and what work you do. I had a discussion recently with a practitioner who was thinking of doing fixed fee for family law, and what he was talking about, which I thought was quite good, was a fixed fee excluding court work.
Okay.
So for work excluding court work.
So it's a mixture.
Yeah, it was a mixture. So it's a hybrid. So fixed fee up to the first day of hearing, excluding court work, with court work to be charged at a set fee of a half day or whatever it was. And we're still sort of playing around with that model, but I think it's got real potential. But you don't necessarily have to lock yourself into fully fixed fee. And for a litigated matter, I think that's probably not...
Sounds like a sensible approach. Yeah. The other risk minimisation point you had was around getting as much information from the client as you can before you start. If you've given a fixed fee estimate and then something comes to light that would have been nice if the client had told you from the start, should you be on the front foot getting in there and revising your fixed fee? Or?
Absolutely. I mean, fixed fee does reward efficient practitioners. You're not getting paid to run up, hours and hours of of work, and it can, lower the potential for payment disputes. But if something comes out of the ordinary, then it is important to be proactive. It gets back to what we were talking about at the start of the conversation, proactive, not reactive. It's also quite important, if that happens, that you actually look at what you define the scope of work as. And is this falling outside the scope of work, or is this completely changing the game plan? Because you can't just sort of change your mind halfway through and go, oh, well, the fixed fee's not working for me now. You've got to be very careful about that. So I think it's very important in your disclosure that you've addressed that situation. And, you can, with fixed fee, you may factor in what's effectively a risk fee. So with a fixed fee, you might be building in a contingency already of, 1,000 or 2,000 or whatever the number is, or a 20% sort of risk fee being factored in. But you do have to bear in mind that if you've done that, if you end up doing less work, then you really shouldn't be charging the full amount. So fixed fee really isn't set and forget. And I think there's a tendency to think that it is, but the way the uniform laws operate and the legislation that we practice under doesn't permit us to behave like
so people
that.
who think that fixed fees are a bit of a panacea for people who don't like time recording, would you be inclined to think that they probably ought to be recording time anyway?
Absolutely, because as I said, you can always ask as a client for the itemised bill. Under uniform laws, they've only got 30 days as a client. Now it's much less open-ended than the previous Act, but there still is that provision to ask for the itemised bill, and there is still that requirement that our fees have to be fair and reasonable, and that is a positive obligation that came with the uniform laws. Fixed fee or not, that obligation doesn't go away. And if you're not recording your time, if you're not keeping track of where you spend time, how do you know if your cost estimates are accurate? How do you know if you're charging the right amount, or you're overcharging or undercharging? And, how do you get around complications? You need to think about that. So I think getting disclosure right for fixed fee can be very difficult. I'm not saying it can't be done, but it's not a set and forget. As you say, it's not a panacea for everything that you don't like about costs.
It seems like the area of costs continues to present lots of challenges to solicitors, and I guess the message is that there are responsibilities, expectations and rights for the solicitor, but there are also responsibilities, expectations and rights for the client, and we can't lose sight of that need to be fair and reasonable. One of the things that I feel is often overlooked by lawyers is that it's reasonable for them to factor into their value proposition the risk and skill involved in the work that they do. And I think that a lot of lawyers struggle with that and struggle with even valuing for themselves the level of their own knowledge and skills. But I think finding a way to have that conversation with clients that conveys to the client that what they're actually getting from the lawyer has real value is perhaps key.
I'd agree with that. I think all of those things that you've touched on there are really important in managing that client relationship. And that's what it really is. It is a relationship. It might be a relationship of circumstance, it might be a business relationship, but at the end of the day, it is that relationship that you're managing.
Well, thanks so much for joining us today, Jacqueline.
Thank you. It's been lovely.
Thanks for listening to Risk on Air by Lawcover. Join us for the next episode and subscribe to stay up to date. For cases and references mentioned in each podcast, visit lawcover.com.au.